Hi, I'm Anna Denton-Jones, and in this fourth Knowledge November video for November 2023, I'm just going to give you a reminder of some of the key things to think about when it comes to changing contracts of employment. So the first thing to think about is the redundancy angle. Now, I know you're going to say, well, we're not actually going to lose anybody, because theoretically, if you can't reach agreement, we might end up having to end current contracts to offer new ones. Technically, that is considered at law to be a redundancy situation. So a case called GMB and Mantruck in 2000 confirmed that collective consultation in terms of Section 188 of the Trade Union Labour Relations Consolidation Act does apply. So potentially 90 days pay, protective award if we don't do it properly. Also £5,000 potentially criminal angle if we don't lodge form HR1. So whilst you might not have the intention of losing anybody, there may be hoops to jump through there. We also need to be thinking about any 2P protected staff. Following a 2P transfer, we shouldn't be changing terms and conditions unless we've got an economic, technical or organisational reason entailing changes in the workforce. And that phrase, entailing changes in the workforce, essentially means a redundancy exercise. So a change in numbers of staff alongside the contractual changes. So combining the two. So watch out for that one. We need to think about collective agreements with trade unions and information consultation of employees agreements as well. Some organisations have. We need to be careful about the pensions angle. If there are specific changes to pensions, then there is a 60-day consultation period attached to that we need to think about. We also need to be thinking about whether any specific groups might be able to claim some form of less favourable treatment. So classic example very much of the current times would be an employer saying, right, that's it, everybody back to the office. In that kind of example, women with childcare responsibilities, caring responsibilities are likely to be able to argue that their group is going to be impacted negatively compared to others by such a rule. Disabled employees might be able to argue the same sort of thing. So watch out for the discrimination angle. In that example, I was talking about indirect discrimination. Changing working hours, of course, has a knock-on for things like working time regs and breaks, rest periods, and all the regulatory framework there. So we need to make sure that whatever we do introduce is compliant. And finally, last but not least, where we are changing things, we've obviously got obligations under the beginning of the Employment Rights Act to set things out in writing to our staff. So where we have changed things, we've got to do an update to people in writing, and failure to do that can obviously result in an award of between 2 and 4 weeks' pay in a tribunal. Now that's where somebody's already got another claim and they add that on. It's not a standalone right, but it's another way of people currently making potentially between 1,286 and just over 2,500, where employers have not dealt with that properly. Hope you found that a useful summary of some of the things that we've been talking about this month.